injuries and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Hello and welcome into the attorneys. Thanks so much for joining us tonight. We appreciate the next half hour that we're going to spend together, and right at the front, want to invite you to get your questions into us and our panel of experts. Our goal here tonight is to provide information that will answer your legal questions. Several ways for you to get in touch with us. You can call, text, or email. That information will be at the bottom of the screen all throughout the evening. And leading the way tonight, as is the case oftentimes, from the firm of Hollis, Wright & Couch, good to see Josh Wright once again.
Good to see you. Hope you had a good week.
Indeed, I did. So.
Good. You know, we are real pleased to do this this show. Yeah, I'll preface by saying this isn't an indictment on all doctors, because certainly there are lots of doctors doing it the right way. This show is about what you do to protect yourself and your family under circumstances where it's not being done the right way. Right. When we talk about medical negligence under Alabama law, we talk about Dennis Goldasich, because he is just excellent in this area. It's why we brought him on the show. We're super pleased he is here, and he's going to be answering some questions today, not just about how to identify medical negligence, but what to do in circumstances where there is medical negligence and you need to protect yourself.
Well, Dennis, good to see you.
Thank you. I appreciate the invite to be here, and it's an honor and a pleasure to be on the show.
Well, nice to have you here once again. Talking about medical negligence, maybe a good launching point is just an overview. Let's start with the basics. Help us understand medical malpractice.
Well, medical malpractice is a term that most people have probably heard of but may not know exactly what it means. What it means is that in the provision of medical care, a health care provider, whether it be a doctor or a hospital employee like a nurse, fails to follow the standard of care or fails to follow the way other doctors or nurses treat the same or similar condition. And in order for it to be a complete medical malpractice claim, you have to have several different elements. You have to have a failure to follow the standard of care or a violation of the standard of care, and you have to have that violation of the standard of care cause an injury. And when you have those two things, and you can prove those by substantial evidence in Alabama, then you have a potential, and I say potential because not all of the cases that meet those elements end up being a successful claim, but you have a potential medical malpractice claim.
David, the laws are tough in Alabama, and we're going to talk a little bit about that today, but this is a major problem, not just for patients but also for doctors. A recent study from 2008 reported that the total cost to hospitals of medical negligence and events is as much as $324 million just at that time frame, that snapshot in 2008. Somewhere between 17 to $29 billion has been assessed as the total cost associated with the loss to society from health care increased costs to Medicare, Medicaid costs to lost income costs, etc., based on medical negligence. So it's a big deal, and it's an issue that impacts a lot of different people around our country. In fact, 15 to 20,000 people file lawsuits every year over this issue. But what we're going to talk about today is about Alabama's law, how it's unique, how it's very difficult to be successful in some of these cases, but some of these cases are very warranted and should be filed.
And you say medical malpractice cases are more expensive? And if so, why?
There is no question that medical malpractice cases are more expensive than most any other type of case. And that's for one reason only. It's because the legislature in the state of Alabama requires that you have experts that are similarly situated to the doctor or the health care provider that was involved in the care that you're complaining of. And what that means is that in order for example, if you had a case that you were complaining of and you said, Dennis, I want to file a medical malpractice case, and it involves a nurse and it involves a doctor, what I would have to go do is find in another state, usually, find a doctor that was willing to review the case, look at all the medical records for a significant fee, and then be willing to come testify in the state of Alabama. Then you would also more than likely need a causation expert, someone that would provide you testimony that would say, in my opinion, that conduct caused that injury. And when you get to the end of the case, and you've had all these experts that you've had to hire, and the other side have hired experts, it's a tremendous cost, oftentimes upwards of $100,000 just to get a case to the courthouse door.
Wow. We'd love to hear from you throughout the show. You'll see at the bottom of the screen ways you can call, text, or email. Email, a convenient way for you to reach us right here during the show. A question here. I was told by an attorney that the proof is much higher in a medical malpractice case than with other cases. Is that true?
Go ahead.
What we're looking at in burden of proof is a couple of different things, and your question is general in some part. Most of the time people have seen TV shows where they're talking about beyond a reasonable doubt burden of proof. That is in criminal cases where a criminal defendant has the right to require the state to prove beyond any reasonable doubt. That's not what we're dealing with here in a civil malpractice case. In a car wreck case, you look at the scales of justice and which evidence weighs more than the other. The medical malpractice standard of proof is somewhere in between that. It's called a substantial evidence rule, and it's where along the line we really have no definition of it. We just know that it's somewhere below a criminal standard of proof and somewhere a little bit above the general civil burden of proof.
Okay. Another question here, and you touched on this a little bit, Dennis. The question is, I was a juror on a medical malpractice case where the plaintiff used 3 doctors from other states as expert witnesses. Why so? How come lawyers don't use Alabama doctors as experts?
Well, it's a problem. It's a problem that we, in representing injured victims and people that are going up against doctors that have committed malpractice, have in prosecuting these claims. Most of the doctors in this state are insured by one of a handful of insurance companies that will, and I'm going to catch some heat for this, but without a doubt, I've heard of significant ramifications being placed on, or pressure being placed on a doctor for being willing to review a case for me. And it's because they say it's basically like a agreement of silence, that if there's another doctor within the state, then there's pressure put on other doctors within the state not to testify against them in a court of law. So it forces us as lawyers to have to go outside the state of Alabama all the time. If we ever are able to hire somebody within the state of Alabama, it has to be outside the region. There's no way that we're going to be able to find a doctor in the same geographical region, like Birmingham doctor against a Birmingham doctor. I've just not seen that happen in my practice.
And it's one of the things that makes these cases a little more complicated, because often it becomes abundantly clear to the jury during these cases that the doctor has got a local physician that is testifying on his behalf that he did not violate the standard of care, and the injured victim oftentimes is presenting doctors that are nationally renowned or at least outside the state of Alabama. And so that causes a little bit of an issue. It's one of those additional hurdles in a medical malpractice case that you have to jump over in order to be successful in the case. We also talked about the costs and how much more expensive it is. Part of the cost that's driven up, as it was indicated by Dennis earlier, is this fact that you've got to go outside the state to go get other physicians to testify as to causation.
All right. On that note, we will take our first break of the evening with 2 full segments remaining. Plenty of opportunity for you to get in touch with us. Again, you can call, text, or email us. Would love to hear from you. There are the numbers and the email information right there. Also, a reminder, on Facebook, you'll find Hollis, Wright & Couch. Just search the firm name, Hollis, Wright & Couch, and you'll find them on Facebook. On Twitter, they are at Hollis_Wright. More on medical negligence coming up right after this short break.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Welcome back into The Attorneys, getting some great feedback from many of you tonight. Going to present your questions to our panel of experts on this topic of medical negligence. But just a reminder, throughout the program, you'll find ways for you to get in, just in case you just joined us. That information, you can call, text, or email us. We would absolutely love to hear from you. Gentlemen, as we were heading to break, talking about the hurdles of medical malpractice cases, you often hear, I don't know if it's true or not, that the medical malpractice cases are harder to prove. What are some other hurdles that you run into with these type of cases?
David, there are a number of different hurdles that we run into when we're attempting to represent a victim of medical malpractice. First and foremost, one of the biggest hurdles that we run into is juror bias. People love their doctors, and they want to view their doctors in a way that they view their own doctors. And so they give doctors the benefit of the doubt most of the time, especially when you have a victim that's deceased. If you have a wrongful death case, we're not allowed to talk about what the victim liked to do, or what they made in income, or their lost wages, or their pain and suffering, or what the family feels. And so all of the bias and the sympathy goes to the doctor that's in the courtroom. Another problem that we have, or hurdle that we have, is unlike other cases like product liability cases, if there's a particular doctor, for example, that has a history of drug abuse and has a substance abuse and has operated on and committed malpractice 10 times in 1 week. Because of the laws of the state of Alabama, we're not allowed to get into any of the other incidents at all. We are limited specifically to the very incident of malpractice during that particular visit of care. For example, in automotive cases, and I know that many people are familiar with the Ford and Firestone litigation, the lawyers were able to get into the hundreds and hundreds of other lawsuits and other injuries that occurred because of the product failure. In medical cases, we're not allowed to do that at all. And so, according to the Medical Liability Act of Alabama, there are very stringent limitations that are placed on the evidence that we can put forth and let the jury know about in these type of cases. We're not allowed to mention insurance or the amount of insurance coverage. And so there's, the jury bias, the stringent proof, the inability to prove other similar incidents all cause a significant hurdle for plaintiffs to overcome.
These issues have been and are the subject of consistent debate. The legislature has enacted the Medical Liability Act and has amended it a few times, but ultimately the Medical Liability Act kind of governs these issues and defines what you can and cannot prove. And doctors have a prominent, very prominent group that lobbies for them and has gotten some good legislation. And at the end of the day, it just makes it a little more difficult to prove these claims. Like we talked about on the top of the show, we're not indicting the industry, not indicting that all medical care is bad. In fact, to the contrary, we have some amazing doctors in this area that do awesome work. But for those that are not doing it the right way, there need to be people out there to keep them in check. And you really have two sources. One is the medical board in Montgomery, and number two is the victims that are willing to press the issue from a medical negligence perspective. I'd also say this, one additional hurdle that we hadn't touched on. Oftentimes hospitals will do quality assurance evaluations of their physicians. Even if they determine that there is a problem associated with the physician, they recognize that that determination is never subject to litigation, never subject to admissibility in a case, so they can keep a doctor longer at a hospital based on their own internal standards. They're going to make those judgment calls, but they could keep a doctor longer, and we've seen it happen before.
Let's head to more of your questions. Again, that information at the bottom of the screen. David checked in an email from him. What do you say to those people who believe that malpractice lawsuits are driving up the cost of health care for everyone? You want to fill that?
Sure, I'll be glad to talk about that. There's been studies that's been done consistently over about the last 20 years trying to determine whether these claims that came directly out of Karl Rove's mouth from Texas, where he decided that in order to get George Bush reelected in Texas, that he was going to create two different issues. One, he was going to try to create an issue on Christianity and the abortion issue. And two, he was going to try to scare everyone into believing that there was a need for significant tort reform. He was very successful on doing that, both on a statewide and a national level, and got George Bush elected. So going back to your question, there was a scare tactic that was created back in the early 1990s in order to try to institute medical negligence caps to protect the insurance companies that were supporting him. Those statistics have never panned out, and what it turns out, according to the studies that have come out lately and that have evaluated those claims, is that really bad investments and increased desire for profits by medical negligence liability companies are really what's driving up the cost. The number of lawsuits that have been successful has gone way down, but the premiums continue to go up, and there's only one factor there, and it's the profit that the insurance companies are making. And so there's a propaganda that's going on right now trying to convince everybody in the state of Alabama and everybody across the country that medical malpractice claims are driving up everyone's health care cost, and that's just simply not true.
The reality is the number of malpractice claims filed nationally has decreased sharply in the last 10 to 15 years. I mean, sharply. Probably more than any other type of litigation, I would imagine.
All right, back to our questions is something, Josh, that you touched on. You touched on the state board. Isn't there a state board that can deal with complaints against doctors? And if so, why is the number of disciplinary actions against doctors so low if there's a board set up to kind of do that? Yeah,
there is a state board, no different than for lawyers. We have a state bar association, and it's similar. And they have an investigatory branch that does evaluate acts of medical negligence or alleged acts of medical negligence and misconduct by doctors. Probably no different than many boards out there. They have not been known for handing out harsh penalties. Right. And there are a lot of reasons for that we probably could go into in 3 or 4 shows. Right. Suffice it to say, there is a medical board. You do have the right as an individual to submit a claim against a doctor that has done wrong, and it will be investigated by the medical board, no different than it would, for example, through the Bar Association. And I don't know if you want to add anything to that, but I think that's the gist of it.
So that they're dealing with the state board, kind of a similar vein to this next question. Does someone who is not satisfied with the results of his or her surgery have a malpractice case, or somewhere else they can go if they're not pleased?
Yeah, not necessarily, but go ahead.
Yeah, without a doubt, one of the points that I want to make sure is clear on this show is that every bad outcome, every bad medical outcome does not mean that there's malpractice, and there's no question about that. That just because there's a risk of a surgery or there's a risk of a treatment of a procedure and it goes bad does not mean that the doctor committed malpractice. There has to be a failure to follow generally and nationally recognized standards of care. For example, if there's a certain technique to use, or if there's a certain timing in which a drug needs to be given and that's recognized nationally, and the doctor fails to do that and there's an injury, then you have a potential case. But just because that treatment or that drug didn't create the right result doesn't mean that there was a malpractice case at all.
Yeah, and I would just add to that, you know, causation is a critical component in all litigation, and it's even more important in medical negligence cases. We get a ton of calls on a weekly and monthly basis about things that have happened, whether they're calls, emails, texts from the show and from other areas. And a lot of times, there is no doubt that there may have been a violation of the standard of care, or it's a close call, but it didn't cause any real injury. And at the end of the day, if you don't have real injury, even though there may have been a breach of the standard of care, it doesn't necessarily mean that there's a lawsuit. In fact, we would argue that there's not a lawsuit. I think what happens is lawyers that handle these types of cases consistently get a bad rap for some of the lawsuits that are filed that may be considered kind of junk cases, frivolous cases against physicians. I don't think there really are frivolous cases against doctors anymore, given the heightened standards and the cost associated with the lawsuits. But the reality is that there are real, true, viable causes of action that need to be brought by injured victims, by lawyers who know what they're doing, that are not filing frivolous lawsuits. And that's really what we're talking about here today, the circumstances when really there is a breach of the standard of care and it's clear. There's a recent statistic from the New England Journal of Medicine, which is a very reputable journal followed by physicians, that physicians were polled and they indicated, 1/3 of them indicated that someone in their family had been subject to medical negligence. We're talking about a physician's family member throughout their career as a physician. And so, you know, it's a real problem, and even physicians recognize it's a real problem, and good physicians will tell you this. They'll tell you, look, I want to weed out the physicians that are doing it the wrong way because the rest of us are doing it the right way. No different than the lawyers.
Yeah.
You know, Dennis and I would stand up here and say that there are going to be some people that are doing it the wrong way. The ones that are doing it the right way, that's who you want to be. That's the person you want to be and the type of lawyer that you want to be, so you can separate yourself from the others. The same thing is true in medical negligence.
Time for our second break. As we head to break, one full segment remaining, so opportunity for you to get your questions to our panel of experts. Plenty of ways for you to do that. Also, a reminder, you can find the firm of Hollis, Wright & Couch on Facebook. Search that. Also find them on Twitter. It's Hollis_Wright. The final segment of The Attorneys coming up after this short break.
From all of us at Hollis, Wright & Couch, we're glad to have you here with us every Sunday night on Alabama's 13. This week we're discussing medical negligence and medical malpractice litigation. It's information you need to know so that you can protect yourself and your family before and during medical care. Now, we're not saying all doctors commit malpractice. To the contrary, most do it the right way. For those that don't, though, seek legal counsel early. Here are some of the things to remember. You deserve to have informed consent, and this means that a physician must tell a patient all of the potential benefits, risks, and alternatives involved in any surgical or medical procedure. They also must get your written consent to proceed. Be sure to ask your doctor or healthcare provider if they have explained all the risks and alternatives before you consent to treatment. Medical negligence claims are not driving doctors away from practicing. The American Medical Association says physician numbers have been increasing for many years. There are record numbers of physicians in the U.S., and this increase has outpaced population growth. There are twice as many physicians per 100,000 people as there were in the 1960s. The cost for patients who suffer medical error can be very, very high. Hospital costs associated with these errors were estimated at $324 million in October of 2008 alone. Malpractice is expensive for both the doctor and the patient. Now please remember, your call, email, or text to the attorneys is free. All of us at Hollis want to help answer your questions to real issues you face in your life. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on Alabama's 13.
Interesting discussion tonight. Appreciate your participation in it. And it's the final segment here, Dennis. In what you've seen in your years of practice when it comes to medical negligence, what do you most often see?
David, it varies. We receive, oftentimes 20 or 30 phone calls a week with people, asking, do I have a case or do I not? And our office has turned down probably 95% of those cases over the years statistically. But we see everything from people calling in saying, I almost, I feel like there was a medication error and I almost was hurt, or I had a complaint and the doctor didn't address it and I feel like that I was treated rudely. Those are quickly dismissed. But over the years, we've seen cases where people have gone in for a simple sinus polyp biopsy surgery and come out with a severe brain injury because the anesthesiologist failed to administer the proper amount of anesthesia. And we've seen babies that were, for example, I just got through representing a family in Mobile, Alabama, where their premature infant was not given the eye drops that were necessary to prevent a condition called retinopathy of prematurity, and they failed to check her in the right amount of time. They were required to check her every 9 to 12 days, and they didn't check her for about 60 days, and she ended up blind. There's been a number of other different types of cases, and it varies because of the variance of the surgical procedures that are going on. We do see a lot of calls with bad births or birth injuries, because the emotions are so deep in those instances that people tend to call an attorney when something happens to their child during childbirth, and oftentimes those are not cases, but when they are, they're just extremely sad and emotional. And so we see all types of cases and evaluate them on a case-by-case basis.
You know, one thing to add to this point is Dennis was talking about surgical procedures. Really in any procedures being conducted, there's law in Alabama that requires a physician to provide full and complete consent and informed consent. And I won't go into all the details other than to say it requires a physician, especially if you ask, but even without asking, that they advise you of all the potential problems, potential concerns, and potential circumstances that could come out of that surgical procedure. So talk with your doctor, ask them, and make sure you know what you're getting yourself into when you have a surgical procedure.
All right, time just real quick for a final word, about 15 seconds. Dennis, final word from you?
Yes. David, my final word would be that there are a number of different ways and things that can happen during medical procedures, and that all of them don't end up meaning that you have a medical malpractice claim. And I would strongly urge that if someone feels like that they have been wrong, to seek the assistance of a counsel that knows what they're doing and can evaluate the case.
Good final word, gentlemen. Hearty debate tonight. Appreciate your time that you have here with us. Appreciate you watching as well. Here's how you can get in touch with the firm of Hollis, Wright & Couch. Find them on Facebook and Twitter as well. Thanks so much. We'll see you next week. Really interesting discussion tonight. Appreciate your participation in it. And it's the final segment here, Dennis. In what you've seen in your years of practice when it comes to medical negligence, what do you most often see?
David, it varies. We receive, oftentimes 20 or 30 phone calls a week with people